Thank you, Pierre-Henri. Good afternoon, ladies and gentlemen. You're doing fantastically well because we have had an amazing number of subjects to think about so far today, and if your brain is anything like mine, you're probably getting to the stage where you think you need to go and have a lie down because there has been an awful lot to think about. So I'm going to bring us back to reality, or practicality, I should say. My background is as a practicing lawyer. So when I think about cross-border mobility, I think about it in terms of if I was advising a client who was trying to do a merger or get from one country to another, what are the things that I would need to think about? What are the things that would cause me problems? And I have this fantastic opportunity to say what I think that the Commission should be thinking about. I'm not quite sure where Bartek's gone. Maybe he's run away so that he doesn't have to listen to my proposals as to what I think any action by the Commission should have in it. But this is your moment too, so I think, if there are things that cause problems. Here's Bartek. He has come back to hear what I've got to say. If you've got practical problems that you have come up against, now is the time to say so, because the moment when you can influence what the Commission might do is coming to an end shortly, I suspect. I should also make it clear that this is very much my own personal point of view, so no one else is responsible for what I'm about to say. What I'm going to do is I'm going to look at mergers, divisions and conversions, and I'm going to look in particular at what sort of protections might it be a good idea to have both for creditors and minority shareholders, and how could we have better processes, because I'm a firm believer in better processes, meaning a quicker, more cost-efficient process for people. So I think it's important to start off by remembering that for cross-border mergers, we have actually had a success story. Sometimes because people tend to think about, well, what's not working as well as it might be, we tend to forget that the Cross-Border Mergers Directive has really been a success story. And as we've heard already today, when Beckbrun and Lexidale did their study of the merger activity, they said that that had gone up 173%. And that was against economies that were not really in an enormous amount of activity, and where some member states hadn't transposed the directive as quickly as they might have done. And that study said that the directive had been responsible for reducing costs, both the costs that groups suffer when they do one of these operations and the regulatory costs that go with them, and that the procedures were simpler and better. But what the study showed was that we could make things even better still, because being a directive, member states have implemented it in different ways. And so there are differences between different member states in the way that they provide protections for minority shareholders and for creditors. And so when you're trying to do a cross-border merger, what you have to do as a practitioner is not only know your own national system with its own peculiarities, but you have to understand the system that operates in the other country where the company is established that you want to merge with, and fit the two systems together. And in particular, there have been difficulties, particularly to do with the timing of things. So in some countries, the protection for creditors takes place before the merger takes place, whereas in other countries, it takes place after the merger has taken place, which leaves the merged company with some uncertainties. The differences in the protection that's offered to minority shareholders, I think also causes companies some worries. Again, the thing that matters most to a company is, am I certain about how much cash I might have to pay out to minority shareholders for protection? And there's an option for member states, although the directive says a 10% limit on cash, member states have an option to make that higher if they want to. So I think there are things that could be done better. And also, when you talk to people who've done these mergers, have been real difficulties in the past about the way that business registries in different countries communicate with each other and how long that takes. And I certainly see the BRIS project as offering a fantastic opportunity to speed up that process. And I've heard people saying, you know, the registry in our country received a certificate from another country, but it was in a language that they didn't understand. Whereas if you can standardize the information that's provided by using templates and things like that, then it's more likely that the information will become more standardized, and that will also help. The other thing that the study identified was that quite often these cross-border mergers are happening within a group. So worries about minority shareholders aren't there because they're wholly owned subsidiaries. And are all the protections that are provided by the directive really needed? And is there an opportunity to increase the number of cases in which you can have a simplified process for doing the cross-border merger? And I know in the UK, for example, that there have been over 50 mergers, cross-border mergers, registered in the UK so far this year. And it may be that partly Brexit is driving some of this activity at the moment. But it seems to me that we've got a good success story, and we ought to build on that and make things even better where we can. One of the problems that we've got at the moment is working out who counts as a creditor. So in the Hyper-Mercados case, creditors were treated as being the people who have debts that have in fact come into existence at the relevant time. But I think when people think about who are creditors, typically they would also include people who may become creditors after a cross-border merger has happened as a result of actions that happened by one of the merging companies before the merger took effect. So are those people treated as creditors or not? That's maybe something that we could make a bit clearer for the purpose of the process. And as I've already mentioned, different member states have different approaches to the timing of creditor protection. Does that happen before the merger or after the merger? And also, what's the period within which people can claim protection? And what protection can they claim? So I'm going to make some suggestions which the Commission can think about and put into this great pot of ideas that it's mulling over at the moment before it comes to its conclusions. I think it would be a good idea if it were clear that creditors were not just those people who appeared in the accounts that the merging company is using as the basis for its valuations, but that it should be clear that the creditors also include contingent creditors. So, for example, if you are a prospective pensioner of a company and you know that the amount of money that the company is going to pay over the coming years will affect what pension you're able to get, you may be someone who has a keen concern about whether the merged company is still going to be able to provide your pension to you at a future date. Or if you are somebody who's brought a claim against the company and there's litigation pending, but the court hasn't yet decided whether you're going to have your claim declared successful or not, you're also a creditor, I would say, who's got a keen interest in whether the merger goes ahead or not. And also, if you have a right of indemnity from a merging company, which depends on something happening. So, for example, there's been a sale of a division at a previous date, and the company has promised to indemnify you if there is a successful tax claim, which it has told you is highly unlikely to be the case. But if the tax authorities are successful in their claim, that you get an indemnity from the company. I think, although your claim hasn't yet formalised and crystallised, I would say you're still the sort of person who ought to be protected. But I do think it would be very helpful if there were a set period in which creditors had to apply for protection. I've put on my slide, apply to the court for protection, That's because I'm a UK lawyer and that's the way I think. In the UK, if you wanted to have protection, it would be the court that you would apply to, but member states might take different views about who they regard as being the right authority to provide creditor protection, and I would certainly be open to that. One thing that I think would be very helpful would be to make it clear that creditors are only entitled to protection if they can demonstrate to either the court or the competent authority, whichever it is, that they are reasonably likely to be prejudiced by the merger going ahead. Because my understanding of what I've seen so far is that some member states seem to be more restrictive in the tests that they apply than that. And if you're more restrictive in your tests that you apply, then you may be stopping companies from entering into mergers that otherwise would be beneficial to them. So in this balance that we always have to make when we think about company law between the company's interests, the interests of the creditors and other third parties, I think if you apply too strict a test and give creditors too much protection, then you run the risk of damaging the company and therefore the employees that work for it. But on the other hand, I also think it's very important for the company to have certainty about what it can reasonably be expected to do. And so I like the idea of there being a safe harbour for the company. So the company knows with certainty that if it can meet certain sorts of tests, the court or the competent authority will say, yes, that's a good enough protection for the creditor, and therefore they're not likely to be prejudiced, and therefore this merger can go ahead. And that safe harbour could come in a variety of different forms. It might, for example, be an independent expert who would say, our view is that creditors aren't reasonably likely to be prejudiced by this merger going ahead. Or it might be that the company can demonstrate to the court or the competent authority that the creditor will have the same claim against the merged company that it has against the merging company, and that the credit quality of that claim will be as good. And the other thing that I think really matters to creditors is that they can continue to make their claim in the same court that they can make it in before the merger. So if you're a Spanish creditor of a Spanish company and you would be bringing your claim in a court in Spain, once the company has merged and gone to Luxembourg or wherever it might be, that you can still bring your claim in the Spanish court, and that would, I think, give you good protection. Minority shareholder protection, as Bartek has said, is another area where my experience is that every member state thinks that its system of minority shareholder protection is the best system of minority shareholder protection. And as Bartek said, one of the things about this is that very often that minority shareholder protection forms part of a wider law to do with minority protections. And so there may be concerns about carving that bit out of the wider law. But again, what I tried to do thinking about this was to think, well, if I was a company that wanted to do a merger, what are the sorts of things where I think the company should offer a minority shareholder who doesn't want to become a shareholder in the merged company in a different jurisdiction some sort of protection, and how would that work? And many member states have an exit right, but not all member states have this. So that is the right to be bought out as a shareholder, to be paid cash compensation. And also, I think typically what shareholders get offered is the right to go to court and complain about the share exchange ratio that you're being offered, because if you feel that the way that the merging companies have been valued isn't a fair way, and your company hasn't been valued sufficiently well in relation to the other merging companies, and therefore you should have got more shares, that's something that you should be entitled to do. And I think if there were to be a more common approach to minority shareholder protection, some of the concerns that exist about that would be allayed. And that seems to be supported by the responses that the Commission got to the consultation that it did, and also by the draft report of the European Parliament that was published. Now, looking at it from the company's point of view, the company will worry about how much cash it's going to have to pay out. And it seems to me that companies can control that to some extent. So, for example, you could, if you were a company, say, we want to do this merger, but we will only do this merger if 75% of the shareholders vote in favour of it. And then you would know that the maximum number of shareholders that you might have to pay a cash compensation to would be 25%. Or you could put other conditions in, so you can make it a condition of the merger that the merger will only go ahead if the total amount of cash that has to be paid out doesn't exceed a certain figure. Now, I don't know whether perhaps in a recital to a revised directive that might be made a bit clearer, that companies do have that option as a way of protecting themselves, and that might give more more protection in practice. Who should get these rights? Well, it seems to me that you should only be getting cash compensation if, firstly, you voted against the merger. If you voted in favour of it, then presumably you are happy against that. You're happy with that decision. And only where you're going to end up as a shareholder in a company in a different member state. Because I think a lot of the concerns come from the fact that if you're a shareholder in your own jurisdiction, you know what the rules are, what rights you have as a shareholder. Whereas if you're going to become a shareholder in a different member state, you don't necessarily know what your rights would be, or you may have concerns about, being able to attend meetings in that jurisdiction or exercising your rights in some other way. But it does seem to me that to provide certainty for the company, you need to have a limited time period for the shareholder to decide whether they're accepting what's being offered to them by way of cash compensation, and also, importantly, a time limit within which the company will pay out that money, so that you know with certainty that you will get your money from the merged company within a certain time period. And from the point of view of the merging companies, it's much easier if there's a common timetable for that, rather than having different timetables. It looks a bit strange, doesn't it, if you end up with a merged company in Italy, for it to be paying the minority shareholders in Austria within 2 weeks, but the minority shareholders in a different member state within a month or something like that, because there are different time periods in different countries. And also, I think if you're going to be given a right to challenge the adequacy of the cash compensation in court, that should be made clear, and that it should be clear that you have a right to challenge adequacy of an inadequate exchange ratio, either in court or through the competent authority. But again, there ought to be time periods for that, so that the company can plan its timetable accordingly and know what process it's going to follow. We've talked a lot about digitalisation today, and I think digitalisation ought to be able to be used much more in mergers. Obviously, when the Mergers Directive first came into force, digitalisation was still relatively new, and I think people didn't think very much about how that could be better used. For example, shouldn't you be able to put your draft merger terms on the company's website? And provide information to your business registry digitally. Now, in some member states, you can do that already, but shouldn't that be the case in all member states? And as I said before, shouldn't the member state business registries themselves communicate with each other digitally, so as to speed up the process for exchanging the certificates that you give to say that the pre-merger steps have taken place and are right, and also so that the approval of the completion of the merger gets communicated. And we could even extend that at the moment. I think Bartek was mentioning the question of where you've got companies who've got branches in other member states. Sometimes it seems to take a while for information about changes that the company has gone through to feed through to the member states where the branches are registered. But through BRIS, surely we can devise a system where whenever there's a change to the registration of the company in its home member state, that registry then communicates to the registries where the branches are set up, so that people who are dealing with the branches know that that's now a newly merged company. One of the things that I know causes problems in practice at the moment is that in some member states it's possible to challenge the entry into effect of the merger resolution based on certain things, for example, related to minority shareholder protection. And it seems to me that for certainty it would be much better if you weren't able to stop the merger resolution going into effect, and the quid pro quo for giving up that right would be more certainty as to what the right is that you have by way of minority shareholder protection or creditor protection, because the more certain those rights are, the less important it is to stop the merger coming into effect. Extending the simplified regime, my suggestion on that is that if you have one person who owns all of the merging companies, so in my little diagram, say all the three companies at the bottom are going to merge into one company and they're all held by the same shareholder. At the moment, the directive doesn't allow you to follow the simplified procedure, but it seems to me that where you've got one shareholder who owns all the merging companies, why shouldn't you benefit from things like not having to have a report from an independent expert and reduced information in the merger terms, and the companies being acquired not needing to have separate general meetings because the one shareholder is obviously the person behind what's going on. Turning to cross-border divisions, we've heard that we don't have a specific EU measure at present, and the responses to the consultation suggest that it would reduce the costs if we were to have one. And I think that we can use the Cross-Border Mergers Directive as a good starting point to be the basis of EU action on cross-border divisions. There was a report that was done by Professor Dr. Schmidt for the European Parliament, and she said there's a real and urgent need for a special EU framework on cross-border divisions. And although we have case law from the ECJ, we know in practice that unless you have a process that is set out in a legislative provision so that your business registry knows that if you've filed the following bits of paper and gone through the following steps, you can do this division, that it is very difficult to do it in practice. It's very expensive to take cases to court, and it takes a long time. But I think there are some differences about divisions compared to mergers which might merit a little further thought. So, for example, Bartek was talking earlier about how some of the stakeholders are worried that companies who want to engage in divisions are somehow trying to escape real responsibilities that they have. And one idea that I had for trying to reassure people on that was that you could require the directors of the company that wants to divide itself to make a declaration of solvency. And by that I mean a statement that the directors don't know of any reason why, when you look at the new company that you're creating for the purposes of the division, and if the original dividing company is going to still be in existence, that company as well, why those companies won't still be able to meet their liabilities that they're going to be allocated under the division as those liabilities fall due. Because that would be a reassurance to creditors and the public authorities that no one is going to be worse off after the division has taken place than they would have been if it hadn't. one of the important things about divisions is that we know as practicing lawyers that you can't, however hard you try, always be sure of having identified all of the liabilities that a company might have. And so it's quite important in a division that you require the people doing the division to allocate unknown liabilities. I mean, that sounds a bit mad, but you might do your division thinking that you've thought of everything, and then it may be the case that somebody will bring a claim against you at a future date, but based on something that happened before the division took place. And so how is that going to be shared? So you ought to be required, I think, in your draft terms of division to say how that would be dealt with. Say you're splitting your assets and liabilities 50-50 between the dividing company and the new company that you're establishing in the division. Does that mean that the liability will itself be allocated 50-50? Or are you going to have a rule that says you look at the business, say this company you're dividing has two separate businesses, it has a bottling business and a distribution business, and so your allocation might be, well, if the actions were related to the distribution side of the business, then it's the bit of the business that went to the divided company that deals with distribution that's going to be responsible for that. So in a way, it doesn't matter what the allocation is, but I think at least the dividing company should be required to address its mind to this possibility that liabilities might come up in the future that you don't know about at the date of the division. But I think there also needs to be a default rule, just in case people forget, even though there's a requirement to do this. I mean, it seems to me that the sensible default rule should be that the dividing company and the new companies created by the division should be jointly and severally liable for this liability, but that each one should be limited to the net assets that it received under the division. You need that sort of certainty, I think, because if you don't have that sort of certainty, no one will want to do a division, because no one will want to run the risk of taking on a liability where what it might have to pay out is more than the net assets it received under the division process. On the process, I think what we need to do is something very similar to what happens in the cross-border mergers. So you would submit your draft terms of cross-border division to the authority in every member state where the company is involved. So in the member state where the company that's going to do the division exists already, and any member state where a divided company is going to exist at some time in the future. And that the sort of opposite to a merger, it should be the regulator of the country where the company being divided is located that takes the decision as to when exactly the division is going to take effect. And in the same way as I think that for mergers we should have a simplified process where you've got one person who owns all the merging companies. If you are doing a division to subsidiaries which are going to be wholly owned by the dividing company, or one person owns all the shares in all the companies that are involved in the division, it seems to me that there's a good argument for allowing a simplified process for the division there. Next, conversions, and we know that the treaty on the functioning of the EU protects the freedom of establishment for companies, and but we also see by looking at the case law that there's been so far that in practice companies who want to exercise that freedom encounter real difficulties, and they aren't sure what process they should follow. I can tell you that if you were to get in touch with the business registry in the UK saying that you are a company in another jurisdiction and you want to move to the UK, although probably at the moment you may not want to, but if you did, because there isn't a formal process laid down in our company law anywhere, they would be a bit bemused, I think, as to what bits of paper to ask you for and how to go through that process. And I suspect that that's the case in most member states. So what I think is most important is that we do have a process which is set out in a directive that spells out for companies what they need to go through. And similarly, in the member state that you want to move to, they need to have a set process too. Another uncertainty that we have at the moment is if you are a private company in a particular member state, can you only become a private company in another member state? Or if you're willing to increase your share capital and meet the other requirements that are needed to be a public company in that other member state, can you go straight from being a private company to being a public company in the new member state that you want to move to? So there's some uncertainty about what sort of conversions are allowed. And Bartek was saying, you know, can you just move your registered office, or should there be some other connection between the place where you are at the moment and the place that you want to go to? I think there are a lot of similarities to cross-border mergers and cross-border divisions, and we've already heard how in practice you may be able to achieve a cross-border conversion by setting up a new company in the member state that you want to go to and doing a cross-border merger with that. But as someone was saying earlier today, why should you have to go through that more complicated procedure in order to achieve what you want? So what I'm suggesting here is that if you use the cross-border merger directive as changed with the suggestions that I've made already, that would be a good starting point. And that most of all what we need is a clear process set out in a directive. So if you're a company and you want to move to another member state, you should have to provide information to your shareholders about where it is you want to go and why you want to go, and what the effects of that are going to be on employees and your strategy, and that that information should be publicly available in the same way as it would be if you were doing a merger, and that your shareholders should have to approve your proposal at a general meeting, that you need a process under which the member state where you're established at the moment looks to see whether you followed the right process or not. And in the country that you want to move to, their business registry would be responsible for making sure that whatever form you want to adopt, and I would be in favour of allowing a company to go from being public to private, private to public, as long as you meet the requirements in the member state that you're moving to, and that they should be responsible for scrutinising that you've met those requirements in the same way that they would do if you were setting up a brand new company. And that they should decide when the conversion would take effect. Although obviously the registries are going to have to coordinate with each other, because both registries need to know that the requirements in each member state have been met. So the country where you're moving to not only wants to know that you meet their requirements for being a company of the relevant sort, but they also want to know that you've met the requirements for the process in the country that you're leaving. And like mergers, I think we need to set out what the effect of a conversion is, so that it's clear that the company's assets and liabilities stay the same, the shareholders are still members of the same company, and that would provide more certainty for the shareholders. And again, I think that companies should be able to provide all of this information digitally to their business registries, and should be able to put information on their website, and that you should provide information once to one of your business registers, and that should have to notify branches and so forth automatically. I think, again, we need some protections for minority shareholders. So if you're a shareholder who doesn't want to be a shareholder of the company once it's moved to its new jurisdiction, you should, and you voted against, that you should be able to exit for an adequate cash compensation, but that there should be a certain timetable for you to exercise that right, and a certain timetable when you know the company would have to pay you your compensation for that. And that if you felt that the compensation you were being offered wasn't adequate, that you would have a right either to go to court or to a competent authority to challenge that. I think on that it should be clear, because where the company is moving from one member state to another, that the competent authority or the court that you would go to would be in your original member state. So if the company is moving from Italy to Austria, that you would know that you would bring your claim in the Italian courts or in front of an Italian competent authority to do that. You wouldn't have to go to Austria to pursue your right. I think also that there might be some benefit in requiring the directors to make a declaration of solvency. There is an argument for saying that that shouldn't be necessary because the company is still going to have all the assets and liabilities after it's moved that it had before it moved, and it's not a question, as it is in the case of divisions, of dividing those up between different entities. But given some of the concerns I have heard expressed by people, that the companies who are moving are doing so because they're in a parlous financial state, I think it might provide reassurance if directors were required to do that. And again, it seems to me that what directors would say is something along the lines of, we don't have any reason to think that the company will be unable to meet its liabilities as they fall due once we've moved jurisdictions, and that after having made reasonable inquiries before giving that statement. Again, it seems to me creditors need some protection, and that creditors should include not just people who are shown in the accounts that the company uses to justify the move, but also those contingent creditors, so people who might be creditors at a future date. And again, it seems to me that what's most important is that there is a set period in which they can claim their protection, and that they should have to demonstrate that they are going to be prejudiced in some way. And I think that test of having to show prejudice should extend to public administrative authorities. In the past, I know there have been people who've said, well, in particular, we're worried about companies trying to escape tax liabilities, and that therefore the tax authorities need to have special protection. But if the test is, will this company be as able to pay monies that it owes afterwards, after it's moved, as it was before it's moved? And the answer to that question is yes, it is. I'm not convinced that public administrators need a special protection for their situation. But again, I think the company needs a safe harbour, because the company needs to be sure that if it meets certain requirements, that it will be able to go through the conversion process without the risk of unforeseen claims against it. So again, that might take the form of an independent expert to say that creditors aren't going to be prejudiced by the move, or by the company saying, even after we've moved, you will still be able to make your claim against us in the same jurisdiction that you could have done, and that the claim that you'll have against us is a claim for the equivalent value. So those are my ideas, but if you've got other ideas, now is your opportunity to say so, and I can see Bartek is all at the ready to listen to them. Thank you.